Fox Oldies, 98.9 WGNY. And, of course, Bobo here with you on a fun day, Saturday morning. And I have somebody brand new to introduce to you. It's Planning Ahead with Megan Conroy. Megan, good morning.
Good morning. So happy to be here with you.
Oh, it's nice to be able to talk to you, dear. Now, just to straighten things out, now you're a partner of Richard Shapiro and the firm there, right?
I am over here at Blustein, Shapiro, Frank, and Barone.
Yes. Now, how do people get a hold of you, Megan?
Sure. They can call in. Our phone number here is 845-291-0011, or they can send me an email, and all of that information can be found on our website, which is midhudsonlaw.com.
All right. You know, Megan, I'm no stranger to planning ahead. And, of course, nobody really wants to talk about planning ahead, but it's inevitable that we need to think about our last days here on Earth and what we want to do with our valuable assets, correct?
Absolutely. It's vitally important. Estate planning is not just planning for death, although that is part of the plan. It's also planning for disability. And I find that that's a component that really brings people to my door, is they're worried about long-term care costs and what's going to happen to their property after they pass away.
Yes, and of course, the firm you work for, and knowing Richard as well as I do, I mean, the firm you work for is absolutely awesome.
Oh, thank you.
Oh, no, you guys most certainly are. So let's kick this off with planning ahead here on this Saturday morning with a question of all questions. Are you ready for this one?
I think I am.
Okay. Okay. But this might seem like a really stupid question, but it's not, because there's no question that's stupid when it comes down to planning ahead, because people need to know this. If you are a recipient with somebody's last will and testament, but, however, you can't collect what is promised to you in the last will and testament because the assets just are not there, what does that mean?
Sure. So what's important about that question is an understanding of estate planning in general. And you really have to understand that the only assets that will pass through a will at the direction of a will would be probate assets. Probate assets are ones that were titled in the decedent's name alone at the time they died. So it didn't have a joint owner and it didn't have a beneficiary. Sometimes what happens is a decedent, before they passed away, they may have named beneficiaries on all of their assets. And so after they pass, those beneficiary designations will control the distribution of the property, and the property doesn't pass according to the will. If you're a beneficiary named in a will, but unfortunately there's no property to pass through it, you may have no recourse. There may be nothing that you can do. Now, certainly you should speak with an attorney who can counsel you to make sure that those beneficiaries were properly designated and that there really is no options for you to be able to collect under the will. But if there are no assets to be distributed under that will, then unfortunately there's nothing that you can collect.
All right. Now, let me ask you this, because you kind of went over my head there with that a little bit. But
okay.
The situation, if you got contacted by the deceased attorney and told you what what the person wants to leave you in their will, and it's just going to take a little bit of time, what does that exactly mean?
Okay. So that's a different question. That's where we're assuming that there is property to be distributed, but it's just going to be a little bit of a delay before you receive it. Is that correct?
That is correct.
Okay. So that would be because anytime you have property being distributed through a will has to first be submitted through a process known as probate. And probate is a court process. And so as you can imagine, anytime we're dealing with the court system, we are experiencing a little bit of delay there because there's paperwork that has to be prepared and submitted. And then finally, the surrogate court would have to review that paperwork before they can even appoint the executor. even once the executor is appointed by the court, they have a lot of running around to do. There's a lot of things that they have to do before they can start dishing out assets, and so there's additional delays associated with that. So when an attorney contacts you as a beneficiary and says, well, you are getting something, but it's just going to take a little while, it's because there's a whole procedure that needs to be played out before you can actually receive those assets. In our area, we usually find that that probate proceeding will take anywhere from 6 months to a year from start to finish.
Wow. Now, does that apply not only to the residents of New York, but is that pretty much the same thing in all states?
I believe the procedure is very similar from state to state. I really can only speak to New York, but I can tell you that my experience for other states has been that they have a very similar proceeding, almost always a probate proceeding, usually a number of months to sometimes in excess of a year before the assets can be distributed.
Wow. So that means that when you speak of assets, that means that if there is a property to be sold, if there is an estate sale, that individual would have to wait for all that to happen first, correct?
That's correct. Generally, we would want to see the property liquidated to be distributed amongst the beneficiaries. Now, that's not always the case. Sometimes family members will agree to inherit a piece of real estate as a whole without selling it, and they all agree to be co-owners on a piece of real estate. But also, as you can imagine, sometimes that leads to some contention when we have a lot of people owning one thing with different opinions and different abilities to contribute to things like expenses and taxes. We can find that there are disputes that occur. So most often we find the property is liquidated first, which, as you've identified, does take some time. And then once the proceeds are received by the executor, that executor can then distribute them according to the terms of the will.
Well, not to get too personal in all this, but I am the last surviving member of my family. So,
oh, wow.
Yeah, I know. As much as I'm sorry to have to be able to say that, my brother passed away totally unexpectedly, and I was shocked towards the end of October.
My goodness, I'm so sorry.
Yeah, thank you so much. Now, he was a senior vice president of an investment firm, and that's how he made most of his money. He passed away at the age of 85, and he has an estate that's worth millions. Believe me, he really does.
Wow.
So I am mentioned in his last will and testament, but the assets are not quite there, and the executors of his estate, believe it or not, are his old company that he used to work for.
Oh, interesting.
Yeah, so, he laid all this out. So what exactly happens there? Now, I'm not looking for free advice here, but I'm just merely trying to bring up an example to our listeners of what possibly could happen to them.
Okay, sure. So I think some of the underlying information that our listeners would need to know, right, is that your brother must have had a will, and in his will, he's identified who he prefers his executors to be.
Right.
And it sounds like he's identified either people or the company itself to serve as the executor. And the executor plays a very important role. They're the one, unfortunately, tasked with the responsibility of doing all the work to make sure that the property is properly distributed once the court appoints them. Now, just because someone is named as an executor in a will doesn't mean that they have to serve. So whoever you designate is always going to be given the option. And if they don't want to serve, they'll sign paperwork to that effect. So typically we like to see multiple options for executors. We'll name them in an order of succession. So if one doesn't want to serve, it moves on to the next. Whoever is willing to serve is going to submit a probate petition to the court with the assistance of an attorney. And in that petition, they're going to say they are willing to serve as the executor and they've been nominated in the will. There are people who have an inherent right to serving as the executor, So there are family members, like yourself in your example, who would have to sign off on someone else being appointed as the executor, because technically you would have the ability to serve if no one else was named. And so you have the right to say, I don't want that company to serve as the executor. I would much prefer to do it. Now, if you're okay with the company serving as the executor, because, again, it's a lot of legwork, so maybe you don't want to be burdened with that,
Right.
and you want to give deference to your brother's wishes, you can say, I'm okay with them serving as the executor.
Right.
Once the court gets everyone to say okay, then they'll appoint the executor, and the executor now starts their work, their job, which is to collect the assets, pay off any liabilities or debts, and then distribute whatever's left over after that. They do have a fiduciary duty to follow the wishes of the decedent, which is laid out in the will. So it's a very important role. The court's going to oversee to make sure that executor does the right thing.
Right, right. Now, I do know before the sale of his house, they had what they called an estate sale, where that company, his old company in this case, comes in and they appraise everything, and then they have this giant estate sale with everything in his home. Now, I was able to go in there and get some things, given the permission of the company and, of course, his attorney, of getting some mementos, if you would. Only a couple of things that, meant something very dear to me. And that was the case, but I have no idea what's going on now.
Okay. So, yep, as a beneficiary, you'd be permitted to access any of the assets that the will authorizes you to access. So if in the will it says that you have the right to receive certain tangible items, like those mementos, sentimental items, you would be permitted to go through the house, through the belongings, and collect those items
Right.
At your will, right? Everything else, as you've identified, is being liquidated because it's easier to distribute the cash proceeds from the estate sale than it is all these tchotchke items that may or may not have some value. So the executor is doing their due diligence to make sure that you're receiving the maximum amount that you should be under your share by having this estate sale. And really, in some ways, you probably are thankful for that because, as you can imagine, it's a lot of work. So if you had to figure that out on your own, you'd be in deep trouble.
Yeah.
So they're taking care of that work for you, and they're going to then make the distribution of any cash that they receive from the estate sale.
See, that's why I was saying to you, this isn't just information I want for myself. I think this is all viable information that listeners need to know about. So, with all that being said, how does one get to that point of doing exactly what my brother wants to do? How does one make sure all this takes place and happens?
That's a great question. So every person should consider having an estate plan. And I call it an estate plan on purpose. I don't say you should have a will or you should have a trust. Because really, nobody wants a will, right? It's just a piece of paper. It doesn't really do anything unless you know exactly what it's intended to accomplish. So it's important that everyone consult with an attorney. That's always my recommendation. I know there's a lot of other ways to accomplish this, but I recommend an attorney to set up an estate plan where that attorney can have a consultation and guide you so that you know your document is really accomplishing the task that you want it to accomplish. You're going to come in with all of your own personal concerns and goals, and really only a professional is going to know which document is the most appropriate one for you and what the terms of that document should be, right? So I would say the first step is contacting a professional, an estate planning attorney, and ask for an estate plan. You want a comprehensive plan. And by comprehensive, I don't necessarily mean expensive. Sometimes people say, I don't want an estate plan, I just need a will, because they're afraid the plan itself is going to be expensive. It doesn't have to be. It can just be a will, but it should be a will that is crafted to meet your objectives, not just some template that everyone gets as a handout, right? So meet with an attorney to get a comprehensive estate plan where they can discuss your goals and objectives. They can dive into your family situation and see what your assets are so we can make sure that every single thing is accounted for. There are no loose ends.
You know, your firm is absolutely excellent, and I would recommend your firm to anybody. Megan,
Thank you.
Absolutely, Megan. And I mean, Richard himself is just such a wonderful attorney. And speaking with you now for the first time, you are just as excellent. You really are. And of course, you're a partner with Richard's firm. What is the name of your firm, and how can people get a hold of you to make an appointment?
Sure. So again, my name's Megan Conroy. They can call Blustein, Shapiro, Frank, and Barone at 845-291-0011, or they can reach out to us online through our website, which is midhudsonlaw.com.
Now, is that Monday through Friday, or are you available weekend?
Generally, our office is open Monday through Friday, 9 to 5. We do have an answering service, so if they need to leave a message, they absolutely can do that, and someone will get back to them promptly. Certainly in this day and age, we're kind of always checking emails, so if it's an urgent matter and they need to send an email, that's okay too.
You know, also, there's something else that your firm does that I happen to love too. Are these workshop sessions for people?
We do, yes. We have public workshops. They are free. They're open to anyone who wants to attend. We are back to doing them in person full-time here in our Goshen office. We have a nice education center to host everyone in. And people who are interested can sign up for those workshops by calling or, again, going online to our website at midhudsonlaw.com. Those workshops are intended to educate the public so that without committing to an attorney, without starting off paying any fees like consultation fees, you can learn about estate planning basics, and you have some idea of what it is you may need to do or what might be recommended to you.
Right, and there's so many things that everybody really needs to know instead of just sitting back in your recliner and, you know, thinking that you filled out a last will and testament 15 years ago. There's a lot of things that you need to catch up on, isn't there, Megan?
That's right. Our firm actually offers a maintenance program. It's elective, so no one is going to be required to enroll in it, but we do encourage our clients to review their estate plan at least once a year. If they participate in our maintenance program, we do that with them, but it's certainly something that each of our listeners can do at home. If you have an old will, I say check in on it, read it. Does it still say what you want it to say? Sometimes people will do their first estate plan, their will, when they have young children, and in there's guardianship provisions, and they have maybe their sister-in-law as the executor, and years have gone by, and maybe their opinions have changed, and they say, oh, no, we don't want her in there anymore.
Yeah.
So it's worth taking a look.
Yeah, a lot of things change. Family members change, opinions change, all of that. And you know what I kind of compare this to? Keeping up with, you know, a maintenance plan with your last will and testament. I kind of compare it to, well, keeping up on a contract for your heating and air conditioning to make sure it all runs properly, right?
That's right. That's why we call it the maintenance program ourselves. It's really important to tune it up every once in a while.
Absolutely. And, of course, laws keep changing, don't they, Meg?
Absolutely. So every year we take a deep dive to see what the new legislation might hold, especially right in an election year, right? But even throughout the year, we see lots of changes, and a lot of it is progress. A lot of it is things that we are happy to see change, but it's going to affect the way we're planning and what we're doing and the tools that we're using. So in our maintenance program, our clients actually benefit from getting updated documents each year that now comply with the new legislative provisions. Again, it's not required to be in a maintenance program to do that. It's just important to think about that plan every so often and be conscious of the fact that the laws may have changed.
Absolutely. Coming back full circle again, it's like my brother's house. There would be no way that my wife and I would ever want to live like that. I'll tell you that right now. There's just no way. I mean, first of all, I don't know how anyone would be able to afford the taxes on a place like that. Second of all, I can see I mean, the house is magnificent, don't get me wrong. But the house itself, it's very well done. And I can see a mom and dad and 2 children living there. You know, seriously. I mean, my wife and I don't want to live like that. We want to be very, very simple, just the way we are, right where we are. So it's very, very important that if you're unaware of what a deceased person may have left you in their last will and testament, it doesn't mean that you have to accept all of that and what they left you, does it?
That's right. You certainly have options. So in your example, the option is, while you still intend to inherit the asset, maybe you're going to inherit it in a different form. You don't want to take the house itself because it's not something that you and your wife can use and enjoy to the full extent, but maybe it'll be liquidated. And so the proceeds from the sale are much more something that you guys can use and benefit from. So if there's an asset that you don't necessarily want because it's not something that's usable, you can consider whether or not you can liquidate it. If not, you always have the option to disclaim the interest in the property. And a disclaimer is something where a beneficiary says, I appreciate that I am a beneficiary, but I don't really want this property. I don't want any interest in it, not even if it was liquidated. And they can submit a formal disclaimer to say that they have no interest in the property and it will move to the next beneficiary.
You know,
I don't see that frequently, but certainly it's an option.
You know, unbeknownst to me, and my brother was a very private individual, he kind of threw in a conversation I was having with him. He said to me, Bob, is there any way that you and your wife, if anything ever happened to me, would want to take over my home here? And I immediately said to him, absolutely not. I'm not going to pay $28,000 a year in taxes. No way. Yeah, oh, no. And I told him, why would I want to do that to myself? He said, okay, just asking a question. And that was the end of that. I mean,
just enough to scare you.
Oh, I mean, think about that. $28,000 a year in property taxes alone. Could you imagine?
I can't. Nope.
No. I would never be able to afford that. I'll tell you. Megan, it's been such a wonderful breath of fresh air being able to speak to you this morning. Nothing against Richard, believe me. Nothing against Richard. But, of course, it's always planning ahead. And it's something that we always have to think about doing in life, whether we want to do it or not. I mean, some people are lazy. They just sit back and let the pieces fall where they may. And you can't really let that happen anymore, can you?
No, that's not a great idea.
Of course, with things changing all the time, oh, my heavens. I mean, a person that just sits back thinking, all right, my last will and testament, I have a revocable trust, irrevocable trust. I don't have to worry about anything anymore. That was all done 10 years ago. That's not really the case, is it, Megan?
No, as we were just discussing, really maintaining the document once you have it in place is going to be the only way that you can guarantee your objectives are met. Like you said, your goals change over time. Maybe when you first did that document, you were worried about young children. Later on in life, you're more worried about the cost of long-term care.
Yeah.
So your plan should change as your life changes.
Absolutely. And the other thing, Megan, you know, in our future conversations, we're going to be talking an awful lot about health care and what happens to an individual when their health goes down the drain and where they need to be put and who pays for that and what happens. That's in future discussions with you.
That's right. Yes, we'll spend a lot of time, or as much as the listeners want to hear, I suppose, but we can spend a lot of time talking about the cost of long-term care, what happens as your health is declining, who's responsible for the costs associated with that, and how can we mitigate those costs.
Yeah, that all happened with my mom. I mean, sad enough to say, but she ended up with dementia and Alzheimer's. And she did not want to be taken to a facility. Instead, she wanted care being brought to her in her own little home where she knew and loved for all of her life. And that's
sure.
And that's really sad when you think about it, you know? I mean, if you can afford to do something like that, I mean, good for you. Good for you. But hospice had to come in, and it was a lot on the family. It really, truly was a lot on the family. But then again, you can't be selfish, and you have to think about the one that is grieving with an illness that,
sure,
you know, and their wishes and what they want, right?
That's right. It's important to sort of keep the important people at the top of mind and their safety and their care. So those would be your loved ones who are declining in that moment. But like you said, it's a lot on the family. It makes things a little easier when that person has done some planning before they declined. They have the appropriate documents in place. They know exactly what they want. Like your mom, in her case, she didn't want to be in a facility. She knew that. At least you knew what direction you were heading in, and she gave you that guidance before she started needing the care, right?
Yes.
There's no question. It's hard on everybody, but having a plan in place does make it a little bit easier.
And it makes it a lot easier when you have a great attorney at your back watching everything and being so involved in what you need to do. Megan, I can't thank you enough for being here with us this morning with planning ahead, and I'm looking forward to future conversations with you, dear.
Same here. Thanks so much, Bobo.
Absolutely. Now, don't run away. Again, tell us the name of the firm that you're with, your name, and how people can get in touch with you.
Sure. My name is Megan Conroy. I'm an attorney at Blustein, Shapiro, Frank, and Barone. You can reach me at 845-291-0011 or through our website at midhudsonlaw.com.
And you're not just an attorney, Megan. You are a partner with
I am, in fact.
Yes, and I'm so proud of you to be able to say that. I really am.
Thank you.
I really am. Megan, have yourself a wonderful weekend.